local bodies. We have completed our discussion on PRIs, Panchayati Raj institutions. We have seen the constitutional aspects of the PRIs. We have seen the constitutional aspects of PRI. See, one more article that I would like you to add here in PRIs, which we have not discussed, is Article 243G. Article 243G. It deals with Article 243G. It deals with powers, authority and responsibilities of panchayats. Power, authority and responsibility of panchayats. Now, sometimes you also get a question on this very idea as to what is the constitution visualizing, what is the role of panchayats, because speaking of establishment of legislatures, legislature basically has to do with law making, but that is not the role of panchayats. That is the role of state legislature as well as the union legislature to do what? To enact laws. But that is not something that is the role of panchayats. Panchayats have been conceived under the constitution to have a very different role. What is that role? The role has more appropriately been considered to be first of all, a body that is responsible for planning, economic development, and social justice. For economic development and social justice. Also a body for implementation of programs for economic development and social justice. For economic development and social justice. So when we look at the role of the PRIs, the role of PRIs that have been conceived, it is, what you should understand is that it is a different, role than what we conceive with respect to the legislature. Legislature is responsible primarily only for ensuring that there are laws that are enacted, and there are, to a certain extent, there is some kind of check that is imposed on the Council of Ministers, that is executive. But here, if you look at the role that has been conceptualized by the Constitution, the role is of both planning as well as implementation of economic development and social justice in a particular region, which means that the body has not necessarily been conceptualized as a legislature which is responsible for like making laws or making certain rules, regulations at the lowest level. That is not what the panchayats are basically doing. They are responsible for planning and implementation. They are responsible for planning and implementation of economic development in that local region as well as social justice. Clear? Article 243G also mentions in what capacity, that means in what cases, in what areas will it act as a body of planning and implementation. In that case, you will find that it has been mentioned under the 11th schedule of the Constitution. 11th schedule of the Constitution details No, it details those areas in which they are to act as a body of planning and development. To act as a body of planning and development. Clear? So the 7th schedule, the 11th schedule, and accordingly all the matters that are mentioned in the 11th schedule for them to act as body of planning and development, planning and implementation for economic development and social justice. Clear? Understood this idea? Have you understood this? Write this down. The legislature of the state may by law provide panchayats with such powers and authority as may be necessary to enable them to function as institutions of self-government, and such law may contain provisions for preparation of plans for economic development and social justice and implementation of schemes for economic development and social justice on those matters listed in the 11th schedule. Clear? So when we talk about the 73rd constitutional amendment, 73rd constitutional amendment also not just added part 9 to the constitution, it also added the 11th schedule to the constitution. Clear? And in this 11th schedule, what are the areas in which the PRIs, the Panchayati Raj institutions, can work? It has been listed in this 11th schedule. Clear? This is about the panchayats. Now going back to the our last class, if you look at the last provision that we discussed, there was how this can be extended by the parliament to the scheduled areas. Now how the provisions of part 9 can be extended by the parliament to the scheduled areas. That is, if the parliament passes a law and extend it to those areas which are mentioned under article 244 of the constitution, which are called as scheduled areas. Accordingly, there has been a law that has been passed by the parliament called as the PESA Act. So give this particular subheading, PESA Act. The provisions of, what is the full form you can write? Provisions of panchayats. Provisions of Panchayats, extension to Scheduled Areas Act. Extension to Scheduled Areas Act. Scheduled Areas Act 1996. 1996. See, try and understand this idea, what I am trying to say, try and understand this well. If you see article 243M, Article 243M explicitly mentions that this particular provision is not applicable to certain areas, and specifically it has been mentioned under the clause 1 itself. You have written that it is not applicable to scheduled areas. That means those areas that have been mentioned under Article 244 of the Constitution. You have seen that there are certain states, some parts of certain states such as state of Assam, state of some other states are there. In fact, scheduled, if you look at scheduled states, there are some areas in around 10 states which are considered to be scheduled areas. What is this scheduled areas? These scheduled areas simply means that they have a dominant tribal population. These areas, they have a dominant tribal population. So you will find states of Gujarat, states of some part of Rajasthan, some part of Jharkhand, Chhattisgarh, MP. All these states have some areas which are declared to be scheduled areas. They have a dominant tribal population. And because of this dominant tribal population that is there, what we see is that we have not completely extended. Originally, if you look at the 73rd Constitutional Amendment, originally the 73rd Constitutional Amendment has not been extended to this particular area. Clear? Then we passed a law in 1996 which is called as the PESA law, Extension of Services Act, Extension of Services to Scheduled Areas Act. That is what is called as the PESA law. And in this PESA law, what did we do? We extended the 73rd Constitutional Amendment to these scheduled areas, because under Article 243M itself, if you look at what you have written, the last paragraph, it says that the Parliament of India has the power to extend the 73rd Constitutional Amendments to the scheduled areas. So if they pass a law to this effect, if they pass a law, they can do what? They can extend the provisions of the 73rd Constitutional Amendment with some exceptions and modifications to the scheduled areas. And what is this PESA law? PESA law basically deals with this very idea that it has extended. The PESA law has done what? It has extended the 73rd Constitutional Amendment to the scheduled areas. It has extended the 73rd Constitutional Amendment to the scheduled areas and added some exceptions and modifications. So what are those exceptions and modifications that have been mentioned in the PESA law itself? What are those exceptions and modifications? It has been mentioned in this particular law. Understood this idea? Have you understood how we have extended this, the procedure? It has been mentioned under Article 243M itself. It can be done how? It can be done by extending, by a law. If a law is passed by the Parliament, by a law that is passed by the Parliament, it can be done. It can be done. But how does the Parliament pass this law? The Parliament passes this law, and the Parliament, while passing this particular law, can also provide for certain exemptions or certain modifications while it is applying the 73rd Constitutional Amendment. And that is what the Parliament has done. Now, as I said, scheduled areas are tribal dominated areas. Because they are tribal dominated areas, that is the reason why tribals have their own way of life. Now, they have their own way of life, and so that we do not interfere with their way of life, what we have done is, we have in this particular law, under the PESA Act, we have empowered the Gram Sabha. Now we have empowered the Gram Sabha of these scheduled areas. Now we know what is a Gram Sabha. Based on our previous discussion, I had defined what is the Gram Sabha. So what is the Gram Sabha? What is a Gram Sabha? From by people. What? Which people? Registered voters of that particular panchayat, that particular village, that particular village. So you find that every village has a Gram Sabha, and all the registered voters of that particular village, they are the part of that particular Gram Sabha. Clear? Understood this idea? Now, what we have done is, so that so that the Gram Sabha, because it comprises of the people of that particular village, what we have done under PESA is we have empowered the Gram Sabha of the region. Like if you see the constitutional provision, if you see Article 243A, going back to our discussion on Article 243A, it talks about what will be the powers and authority of the Gram Sabha. And the power and authority of the Gram Sabha is decided by state legislature. We have seen that also, that it is the state legislature which through a law defines what will be the powers and authority of the Gram Sabha. In this case, that means when it comes to the scheduled areas, this is not true. The power and the authority that is exercised by the Gram Sabha is mentioned under the law itself. That is the exception. It is mentioned under the law itself. And what is that exception that has been mentioned there? It says that the Gram Sabha enjoys almost all powers with respect to decision making for the administration of that particular region. So in scheduled areas, that means in these tribal areas that are there, you will find that first of all, any minor mineral that is there, the administration of this minor mineral, how it is to be done, it is decided by the Gram Sabha. Similarly, when we talk about minor forest produce, how it is to be administered, it is decided by the Gram Sabha. Similarly, when it comes to smaller river bodies, how these river bodies are to be administered, it is decided by the Gram Sabha. When it comes to land acquisition, that is, if the state wants to acquire land in this region, it is also decided by the Gram Sabha whether it is to be done or not. When it comes to selling of intoxicant in the region, it is decided by the Gram Sabha whether it is to be done or not. Similarly, when it comes to organization of some minor fairs, etc. in the region, again it is up to the decision of the Gram Sabha. Similarly, if we talk about money lending exercises, whether it is to be done in this region or not, it is decided by the Gram Sabha. Which means if you look at what is the modification that has been done under the PESA law, the objective of this modification is to empower the people of the region itself to take up all necessary decisions, which previously was in the hands of the state government. Under the 73rd Constitutional Amendment Act, it is under the state government. What are the powers that the Gram Sabha is to enjoy? And what are the powers that the PRIs, the Panchayati Raj institutions have to enjoy? It is something that is under the state government, under the 73rd Constitutional Amendment. But in scheduled areas, in those scheduled areas, it does not fall under the state government. It is directly given to the Gram Sabha. The Gram Sabha is empowered to do or to take up all such necessary action. Thereby doing what? Empowering the people themselves. Empowering the people themselves. So Panchayati Raj extensions are created. Panchayati Raj institutions are created in such region. They are created in such region, but under the law, first of all, the reservation that is extended to this particular region, that is to scheduled tribes, the reservation that is extended in scheduled areas, it is more than 50%. It can be more than 50%. So the seats that are there in the panchayats, they are generally reserved for whom? The members of scheduled tribes. Because as I said, it is a tribal dominated area. So this reservation is even more than 50%, and the Supreme Court has upheld the validity of the law. So when the reservation was extended to being more than 50%, the Supreme Court said yes, it can be done under Article 243M. It can be done. So it has been done. Reservation has been extended, and also the empowerment. It has been the body, the Gram Sabha has been empowered to take up all necessary decisions. It's not up to the state legislature, rather it is up to the Gram Sabha to decide on such factors. Clear? So this is the basic objective or the basic idea behind what is the PESA law. Clear? Understood this idea? Write this down. PESA law. Very important. It is a very important aspect. It's a very important aspect of your discussion. Most of the times the question that arises from this particular topic, it is always with consideration of what is the PESA law prescribing for. Write this down. The provisions of Part 9 of the Constitution, Part 9 of the Constitution relating to panchayats, have been extended to the scheduled areas, to the scheduled areas with such exceptions and modifications, as provided under section 4, of the law. Give a subheading here, write section 4. Nothing in Part 9 of the Constitution, relating to panchayats, the legislature of the state shall not make any law. The legislature of the state shall not make any law, which is inconsistent with the following features. First feature, the state legislature on the panchayats that may be made shall be in accordance with the customary laws, social and religious practices, and traditional management practices of community resources. Second, a village shall consist of a habitation or a group of habitation comprising of a community and managing its affairs in accordance with traditions and customs. Third, every village shall have a gram sabha. Fourth, every gram sabha shall be competent to safeguard and preserve the traditions and customs of the people, their cultural identity, comma, community resources and the customary mode of dispute resolution. Next, every Gram Sabha shall first sub point here, in this point, first sub point, approve the plans and programs for social and economic development, second, are responsible for identification or selection of beneficiaries of any programs. Third, the reservation of seats in the scheduled areas shall be in proportion of their population, provided it shall be not less than 50% of the total seats. 50% of the total seats. 50% of the total seats. Next, the Gram Sabha shall be consulted. The Gram Sabha shall be consulted before acquisition of land in such scheduled areas, in brackets, right, or Gram Panchayat. That means either Gram Sabha or Gram Panchayat. Next, for planning and management of minor water bodies, in such scheduled areas. Next, recommendation of Gram Sabha or panchayats shall be mandatory prior to providing any license for mining of minor minerals in such areas. Next, the Gram Sabha or the Panchayat will exercise powers to enforce restriction on sale of intoxicants, comma, ownership of minor forest produce, comma, power to manage village markets, comma, to exercise control over money lending, comma, to exercise control over institutions and functions, in all social sector, institutions and functions in all social sector, and the power to control over local plans and resources for such plans. This is the PESA law. So you can see that the power has been given to it has been devolved to the lowest level. Next comes the 74th Constitutional Amendment Act, that is Part 9A, Municipalities. The 74th Constitutional Amendment Act 74th Constitutional Amendment Act, which has introduced Part 9A, that is municipalities. Clear? Let's start with first constitutional provisions. First we discuss constitutional provisions, and finally the last part of our discussion here will be the problems that are faced by these local bodies. The last part of our discussion will be the problems. Before that, we start with this idea, that is constitutional provisions, Part 9A. First article here is 243Q. Article 243Q. It deals with what? Constitution of Municipalities. Constitution of Municipalities. Constitution of Municipalities. See, municipalities are also a three-tier body like the Panchayati Raj institutions. At the lowest level, there is what is called as a Nagar Panchayat. A Nagar Panchayat that is formed. Then for some smaller, what you can say towns, there is something called as municipal councils. Municipal councils that are formed. And for the metropolitan, or the big urban areas that are there, what we have is a municipal corporation. Municipal corporation that is formed. So Nagar Panchayats are formed for which areas? These are generally called as transitional areas. For transitional areas, that means those areas which are neither completely rural areas nor they are the part of are completely urban areas. There is a mixed kind of population that is there. They are transitional areas. Municipal councils are formed for what? Smaller towns and cities. For smaller towns or smaller urban areas that are there. And finally, municipal corporations are for large urban areas. Large urban areas. Like in Delhi, you have what is called as MCD, Municipal Corporation of Delhi. So it's for a large urban area such as Delhi, or for that matter, you must also have heard about BMC, Bombay Municipal corporation. So for large urban areas you have municipal corporations, for smaller urban areas you have municipal councils, and for transitional areas you have the Nagar Panchayat. Clear? Understood this idea? Now when we talk about this, what is a transitional area and what is a what is a small town or a smaller urban area, or for that matter what is a large urban area? Who decides this? It is decided by the governor. It is decided by the governor of the state. The governor of the state decides what is a transitional area, what is a a smaller urban area for which municipal councils are formed, and what is the large urban area for which municipal corporations are to be formed. And while the governor decides what is in this particular idea, he takes into consideration what? He takes into consideration things such as the population of the area, the population density, the population density, the economic importance, of the region. Similarly, number of people employed in non-agricultural sector, number of people that are employed in the non-agricultural sector, revenue generated in the local administration, revenue generated, etc. So it does not mean that you will find that a municipal corporation is only there for a area like a metropolitan area. That is not the case. You might find that municipal corporations are also there in a state, in certain states, or for certain cities which may be considered as tier 2 cities. Now, do you know what is tier 2 cities? You will find there are so many cities in India which are not metropolitan cities, but they are definitely urban areas. They are considered to be tier 2 cities. So you'll find in certain tier 2 cities also you find municipal corporations that are in existence. Why? Because it is up to the governor where it is to be formed, in which area it will be a Nagar Panchayat, for which area it will be a municipal corporation, for which area it will be a municipal council. It is completely up to the governor, and the governor takes these aspects into account while he is considering which is a transitional area, which is a smaller urban area, and which is a large urban area. Clear? Understood this idea? Now, whenever we talk about, this particular panchayats, the municipalities that are there, how is they to be composed? That means this is the 3-tier structure that is present, that is mentioned under Article 243Q. But how are the members that are either elected, or who are the members who are given representation to such such organizations? It has been mentioned under Article 243R. So next, give a subheading, right? Article 243R. It deals with composition of municipalities. Composition of municipalities. When we say composition, first, at all the three level, the seats that are to be filled, they are to be filled by direct elections. No, they are to be filled by direct elections, and For this, the area of that particular panchayat or municipality is divided into territorial councils. These territorial constituency is called as wards. Clear? So the most of the members that are there, that are comprising of these three bodies, that are a member of these three bodies, they are elected members. However, the state legislature may by law also provide membership to first, an individual having special knowledge or experience in municipal administration, having special knowledge or experience in municipal administration. Second, members of the Lok Sabha, and state legislative assemblies, members of Lok Sabha and state legislative assemblies in panchayats falling within their don't write panchayats, write municipalities. In municipalities falling within their constituencies. Third, members of Council of States, that is Rajya Sabha, and state legislative councils in those municipalities where they are registered voters. And fourth, the chairperson of committees constituted other than ward committees. The ward committees. What is this ward committee? I am coming to it. Now see, if you compare this very provision to the provisions of panchayat that we have already discussed, in that case we had talked about intermediate and district panchayats, and we had said that even those individuals, members, they are the members of those the members of Lok Sabha or the members of state legislative assembly, they can be given membership. Similarly, the members of Lok Sabha and state legislative assembly can also be given membership in such local bodies, urban local bodies. Similarly, the members of Rajya Sabha and the members of the municipal the legislative councils that are there, they can also be given representation, but they are given representation not from the constituency, because they do not have any constituency. What they have is a state. So wherever they are a registered voter, in all those municipalities where they are registered voters, they can be given membership to those municipalities. Clear? Now the state legislature by law, next point you can write here, write it in the next paragraph. The state legislature may by law may by law also provide for the election of chairperson of municipalities. Election of chairperson of municipalities. That means how they are to be elected, how the chairperson of Nagar Panchayat, municipal council and municipal corporation are to be elected, that is provided by the state legislature by a law. So they can be directly elected, they can be indirectly elected, it is completely up to the state legislature. Completely up to the state legislature. Clear? Now, this individual, if given representation, this individual does not have the right to vote in the municipalities. He does not have the right to vote in the municipalities. All other members have the right to vote except for an individual who has been given representation because of special knowledge or experience in municipal administration. Let's understand this very provision. See, let's take an example to understand this. If you look at these local bodies like the municipalities, or for that matter the municipal corporation, you will find that there is an individual who is either named as the municipal commissioner. Like in all those municipal corporations that are formed, there is an individual who is, a position is created there called as the municipal commissioner. Like there is an individual called as municipal commissioner of Delhi. He is basically like, he's like a executive head of this particular body. When I say executive head, what do I mean? All the decisions that are taken by these bodies, the municipal corporations that are there, the power to implement them lies with this particular body. He is generally a very high ranking IAS officer. So an individual, like if an individual is appointed to MCD, commissioner of MCD or commissioner of BMC, he is a very high ranking IAS officer. Suppose an individual is in this particular position for 5 years before he actually either is transferred or it retires from service. He is in this particular position, commissioner of MCD. After retirement, if he suppose wants to settle in any particular urban area, in that case, if the state feels the need that he is an individual who has suppose 5 years experience, 10 years experience working with local bodies, so he has some specialization with that respect. So what can be done? The state legislature by law they can pass a law, or they have already passed a law wherein such individual can also be given representation. So you as a member will be given you will be going to such bodies, you will be attending all the meetings of such bodies, whatever responsibility is being given to you as a member of such a body, you will be doing all that. What you do not have is the right to vote. What you do not have is the right to vote. So when the municipal council or the municipal corporation is taking a decision, in that case, or the Nagar Panchayat is taking a decision, you will not have the right to vote there. Otherwise, you are like any other member. You are also given representation. You do not have the right to vote, but you have been given representation not because you are directly elected by the people, but because you have an expertise in the administration of such bodies. You have an expertise in the administration of such bodies. And that is the reason why you have been given representation. Understood this idea? Are you getting this? So an individual with special knowledge or experience with respect to the municipal administration, that individual can also be given membership. So tomorrow if you get into IAS and you are appointed to such position, and the day you retire, if you retire in suppose a state in which certain municipal bodies or municipal corporations are formed, you can be given representation in those bodies, but you will not enjoy the right to vote. All other members, that is individuals who are belonging to MPs of Lok Sabha or MLAs or MPs of Rajya Sabha or MLCs, or an individual who is a chairman of some committees that we have talked about, all of them have the right to vote. Who does not have the right to vote? The individuals who are appointed to this body with special knowledge or because of special knowledge or some expertise with respect to municipal administration. See, right to vote, the simple idea here for right to vote is that if this particular body is taking a decision, in that case you will have the right to vote in the decisions or in that particular body. Like whenever we talk about municipal councils and municipal corporations, their responsibilities differ from the responsibilities of Panchayat. You will find that Panchayats have been given some very basic responsibilities, but here municipalities in some areas, municipalities have very large scale responsibilities, or municipal corporations. Like if we talk about Delhi. In Delhi, if you look at the local administration that is there, local administration is basically under municipalities. The municipal corporation that is there, it is all under it. When it comes to suppose all this sanitation related work, electricity related work, all of this falls under municipalities. So any decisions that are being taken there, because such individuals are also the representatives of people, whether they are MP of Lok Sabha, Rajya Sabha or MLA or MLC, so they are given no right to vote here. Consequence is that they are like any other member, and they will also have, because they share this developmental responsibility. An MLC, MLA or MP of Lok Sabha and Rajya Sabha, they also have developmental responsibilities for that particular region. So they share their responsibilities with such local bodies, and hence they should also get proper representation. That is the basic idea. Clear? Next, Article 243S. Article 243S, Constitution and composition of ward committees. It deals with constitution and composition of ward committees. Constitution and composition of ward committees. If suppose this is a particular region and this is a municipality that needs to be formed, so in this case the members, there are suppose 5 members here, suppose just an example. So these are the members. These are what? These are territorial constituencies from which these members are to be elected, and these territorial constituencies are called what? Wards. Clear? So if you are living in an urban area, or if you have been in last 2 years in Delhi also, you will find that there was an election to the MCD, and in that election to MCD you will find that the constituencies are divided into wards. And sometimes you find, if you are visiting a particular place, so you will find welcome to ward number this, that is also written, and sometimes it is also mentioned who is the representative from that particular ward. It is just like an MLA or an MP. Like an MLA and an MP has its own constituency, similarly an individual who is elected to the municipality, they also have their own constituency. That constituency is called as wards. Clear? Now, this provision is very important, so you should understand this. When we talk about Article 243S, what does it deal with? It deals with constitution and composition of, not wards, because wards are territorial constituencies. Ward committees. Clear? What are ward committees? Let's look at that. Write this. Clause 1. There shall be constituted ward committees consisting of one or more wards within a territorial area of a municipality, within the territorial area of a municipality having a population of 3 lakh or more, having a population of 3 lakh or more. Now see, we are talking about these 6 wards. These 6 wards are constituencies. Suppose ward number 4 has a population of 4 lakh. I am not talking about the population who are registered voters. I am just talking about the population. So it may so happen that a ward committee is formed just for this particular ward. Or if it so happens that when we include ward 1, 2, 3, we find that including all the population of these 3 wards, the population is 3,50,000. Clear? So including these 3 wards, we will create a ward committee for these 3 wards. What is the criteria? The population of 3 lakh or more. So with every population of 3 lakh that is there in the municipality, whether they are from one ward or whether they comprise for one or more ward, there will be a ward committee that will be created. Clear? Understood this idea? There will be a ward committee that will be created. Further, clause 2. See, when we talk about population is not same, it is considered to be almost same. And second of all, when we are actually coming out with this, what are the wards? If you remember, we have already discussed this idea of 1971 census. That means when we actually came up with this idea of ward, dividing this, delimiting such wards, we have seen not the 1971 census, but because we have created this body later on, so we had seen that particular census. So that changes, it changes every year, population changes, and based on the population they are coming out with such committees. Clear? So when we say 3 lakh or more, first of all, yes, you are very correct when you say that constituencies are so divided that there is proportion, there is a proportion of population that is there. Absolutely correct. So it may so happen that you get for 2 wards, you get a particular committee, and you get that for every 2 wards. That can also happen. But it can also happen that you get one committee from one ward itself because the population is greater. It is just a flexible provision that has been mentioned here. Clear? Next, state legislature, clause 2. State legislature may by law provide for the composition and the territorial area of the ward committee, composition, territorial area of the ward committee, comma, the manner in which the seats of such committees are to be filled. So when it comes to the composition of these ward committees, and for that matter the territorial area of this ward committee, it is provided by state legislature. What is the composition? 10 member, 1 member, 2 member, whatever, it is provided by the state legislature. Also, the manner in which these seats are to be fulfilled, that means either they are elected or they are to be elected, or within these members itself, they are to be formed, whatever, it is to be provided by the state legislature. Clear? Clause 3. Clause 3. The member of municipality representing a ward within the territorial area of the ward committee shall be the member of the committee, which means the individual who is elected from every ward, all those ward committees that are formed within their territorial extent, they will definitely it is compulsory for them to give membership to such ward committees. Clear? Next, clause 4. Clause 4. These ward committees consist of the member representing the ward, comma, one or more member representing such wards in the municipality, elected by the members of the ward committees, Clear? Shall be the chairperson, further right, shall be the chairperson of that committee, What does this mean? There will be a chairperson of that committee who will either be a member of this particular ward, that means he has been elected to from this ward, so he will act as the chairperson, or any individual who has been elected to this particular committee, that individual can also be the chairperson. Clear? Finally, clause 5. The state legislature can also make provisions for constitution of committees in addition to ward committees. Simply meaning, the state legislature is not prohibited to establish additional committees. There can be ward committees, there can be some additional committees also. Clear? So either you come up with ward committees, you have to come up with ward committees, it is a compulsory provision, but it is up to the state legislature. The state legislature can also establish some other committees, that is other than ward committees, that can also be established. Clear? These are what is ward committees. Now go back to the previous article. You have written chairman. If you look at the composition of municipalities, one provision that you have mentioned is chairman of the committees, that is ward committees. So all these ward committees that are created, there are chairmen to these committees. We have already seen that under article 243S clause 4. So these chairmen that are there of these ward committees, they also can get representation in municipalities. Clear? This is what it was meant. See, next provision is of reservation, and the same provision is applicable. Panchayat and municipalities provisions are same. That means, if you remember, when we were discussing panchayats, we discussed that there are reservation is provided. It is voluntary and mandatory provision. Mandatory reservation is given to members of scheduled caste, scheduled tribe and women. Scheduled caste and scheduled tribe are given reservation on the basis of their population, and women are given reservation at least 1/3. It can be more than that, it cannot be less than that. So this is also the case when it comes to municipalities. So when it comes to the composition of municipalities, or when we talk about these wards that are there, these wards will be reserved for the members of scheduled caste and scheduled tribe on the basis of their population. So if suppose in this particular region 10%, 10% of the population belongs to scheduled tribes. So the number of wards that are there in this particular region, 10% of that particular ward will be reserved for the members of scheduled tribe. Similarly, 1/3 compulsory reservation is given to women. It can be more than that, it cannot be less than that. So out of the total seats that are there in municipalities, 1/3 are reserved for women. At least 1/3 are reserved for women. If you remember, we also talked about reservation being extended to the position of chairperson. So all the chairpersons that are there, whether it is of the Nagar Panchayat, whether it is of the municipal council, and whether it is of the municipal corporation, it is to be reserved again in the same proportion. So members of scheduled caste and scheduled tribe, they get on the basis of the population that they hold. So all the municipalities that are there, according to the population that they have in this region, the position of chairperson will also be reserved. That will also be the case for women. At least 1/3 of the total positions of the chairperson will be reserved for women. At least, it can be more than that, it cannot be less than that. Similarly, when it comes to members of scheduled caste and scheduled tribe, so all the seats that are reserved for scheduled caste and scheduled tribe, out of that seats, at least 1/3 should belong to women belonging to scheduled caste and scheduled tribe. Clear? This is the reservation provision that we have already discussed. It is also extended to municipalities. In voluntary provision, remember what did we say? The members of other backward classes, the state legislature may by law extend reservation to the members of other backward classes as well. But as the terms, as the language suggests, what is the language? What is it suggesting? The state legislature may by law, which means it is not a compulsory provision, it is a voluntary provision. The state legislature may do it, the state legislature may not do it. Clear? Reservation. Duration of municipalities, same as that of panchayats, 5 years. Same provisions that we have discussed there, it is extended here as well. So every municipality also has the tenure of 5 years. Now they have the tenure of 5 years. If they are dissolved for any purpose, then within 6 months elections are to be held. Elections are to be held. If the elections are held after 6 months, the tenure that is there of the newly constituted municipality will be what? The remaining tenure. That is, out of 5 years, if first it was, it has already served 2 years, and after 2 years it was dissolved. So the newly constituted municipality will have a tenure of 3 remaining years. Clear? That was duration. Disqualification of membership, same. Same is the disqualification of membership also. If you are disqualified to be a member of the state legislature by a law, in that case you are also disqualified to be a member of municipalities. Secondly, if the state legislature by law comes out with an additional qualification, like we did discuss the state of Gujarat and the state of Haryana, how in the state of Haryana education has been provided as a ground for qualification. Similarly, how in the state of Gujarat at least one working toilet is necessary, otherwise the individual is disqualified. That is also applicable in this case. There was an exception to this principle, 21 years. If an individual has attained the age of 21 years, he is not disqualified to be a member of municipality. Even when he is disqualified to be a member of state legislature because he has not attained the age of 25 years. Clear? So this is applicable applicable here. No, not in ward committees. Their composition is completely dependent upon, their composition is completely dependent upon the state legislature by law. Whatever the state legislature provides for, it is completely up to that. It is basically those position of municipalities and the wards and who are elected from the wards, that seat is basically reserved. Ward committees is more like an executive body. It is more like an executive body. specifically looking at the problems of this particular region. Municipality is for the complete municipality, whole of this region. For wards, this is for specifically for that particular ward. Clear? So it is like further decentralization. Like if when we talk about Gram Sabha and Gram Panchayat, because we have Gram Panchayat, then why do we need Gram Sabha? So like when we have Gram Panchayat, we still have a Gram Sabha. Similarly, we have wards. We have a municipality, but within that we also have ward committees. Clear? Next, 243W, which deals with powers, authority and responsibility of municipalities. Power, authority and responsibility of municipalities. Power, authority and responsibility of municipalities. Write down. The state legislature may by law. The state legislature may by law provide the municipalities with such power and authority as may be necessary for them to act as an institution of self-government and subject to those to prepare plans for economic development and social justice and in performance of functions and implementation of schemes relating to matters mentioned in the 12th schedule. Next paragraph. Underline 12th schedule. Underline socio-economic development and social justice. Underline that. Underline planning and implementation. Next paragraph, right? The state legislature will also provide for powers, authority and responsibility to the committees to enable them to carry out responsibilities in relation to matters mentioned in the 12th schedule. So these ward committees that are there, what are their functions? It is also decided by the state legislature by a law. Clear? Next, 243Y. 243Y. It deals with State Finance Commission. In brackets mention under Article 243I. 243I. See, the State Finance Commission is the same finance commission that is formed under the 243I. So the same State Finance Commission that is formed to look into the taxes and funds of the panchayats, they are also responsible for taxes and funds of the municipalities. They are also responsible for taxes and funds of the municipalities. Clear? So there are no two state finance commission. There is only one finance commission also responsible for panchayats and municipalities. Clear? Next, 243 ZA. 243 ZA. Elections to municipalities. Elections to municipalities. Here just mention Election Commission of the State. Election Commission of the State referred under Article 243K. Referred under Article 243K. So the same election commission that is responsible for elections to panchayats are also responsible for elections to municipalities. Clear? Next, 243ZC. 243ZC, exempted areas. Exempted areas. Clause 1. Clause 1. Scheduled areas and tribal areas. Scheduled areas and tribal areas mentioned under Article 244. Mentioned under Article 244. So they are exempted. Clause 2. In the district of Darjeeling, in the state of West Bengal, the district of Darjeeling in the state of West Bengal, where a Darjeeling Gorkha Hill Council, is constituted. Third, the Parliament, third clause, clause 3, the Parliament may by law extend the provisions of this part, to the scheduled and tribal areas, mentioned under Article 244. Article 244. Such a law shall not be deemed as an amendment. Shall not be deemed as an amendment under the Constitution. Under the Constitution. So this is the case. Obviously, scheduled and tribal areas, they are exempted. Similarly, the Darjeeling district that is there, because there is already a Darjeeling Gorkha Hill Council that exists, so it is exempted. That particular district is also exempted from municipalities, and this part 9A, it is not applicable there. However, if the Parliament wants, like it has done, like it has enacted the PESA Act and extended the provisions of Part 9 to scheduled areas and tribal areas, similarly, Part 9A can also be extended to scheduled areas and tribal areas. However, this has not yet happened. So, the scheduled areas and tribal areas have been exempted currently. Clear? Now, coming to the two most important provisions of this particular part, that is Article 243ZD and Article 243ZE. If you look at these two provisions that are there, these two provisions deals with a committee called as District Planning Committee and Metropolitan Planning Committee. Now in India, interestingly, if you look at planning, how planning is done basically by, at the union level, there is a body called as the Niti Aayog, and at the state level there is a body called as the state planning boards that take up planning in the state. Before the Niti Aayog, there was a planning commission that was in existence, and it was the planning commission which was responsible for planning. So it used to come out with 5-year plans and sometimes an annual plan, etc., etc. Interestingly, if you look at planning at the union level or at the state level, it is done by bodies which are neither a constitutional body nor a statutory body, which means neither planning commission was a statutory body nor the planning commission was a constitutional body. Similarly, neither the Niti Aayog is a statutory body or a constitutional body. It is an extra statutory, extra constitutional body. So there is no law which allows that legal status to Niti Aayog, and that is the reason why executive can at any given point of time do what? Do away with this particular body, like the planning commission was done away with. Now 2014, 15th of August, while addressing the in the Independence Day speech, the Prime Minister talked about the Niti Aayog and the body Niti Aayog to be replacing the planning commission. See, just by an announcement, planning commission was done away with and Niti Aayog was formed. Clear? Why? Because it is neither a constitutional body nor a statutory body. That is also the case with state planning boards, state planning board. But because planning in India has always been centralized, so it is done generally at the union level. So the most of the plans that are prepared, it is prepared by the central, the union body. Niti Aayog, yes, Niti Aayog has membership of the states also, so states also provide their input there. At the state level, the planning that is done, it is done by a board. There is an institution called as State Planning Board that is in existence. Interestingly, this State Planning Board is also not statutory. In almost all of the states, they do not have legal status. They do not have legal status. Neither do they have constitutional status. But when we talk about the planning at the lowest level, that is at the local level, you have two bodies called as the District Planning Board, District Planning Committee, and the Metropolitan Planning Committee. District planning obviously for district, and Metropolitan planning in case there is a large urban body which we call as metropolitan bodies. The definition is also what we are going to see now. Here you have bodies, two bodies that are responsible for planning at the local level, and they are constitutional bodies. So state or center may non-constitutional, non-statutory body, but at the local level you have a constitutional body that is responsible for taking up planning. This is what is the basic objective of the planning committees that are there at the district level or at the metropolitan level. What is the detail that is mentioned in the constitution? Let's look at that. First, Article 243Z(d), Committee for District Planning. Committee for District Planning. Committee for District Planning. Clause 1. There shall be constituted at the district level, a district planning committee to consolidate the plans prepared by Panchayats and municipalities, in the district, and to prepare the draft development plan, for the district as a whole, underline consolidate the plans. Consolidate the plans. What does that mean? See, we have already seen that when we talk about municipalities and panchayats, what are panchayats and municipalities? They are nothing but a body of planning and implementation. So every panchayat that is there, they are responsible for, they are responsible for preparing plans for the development of their own region. So if it is a municipality in the district, so municipality, and if it is a panchayat in the district, the Zilla Panchayat that is there, these two bodies have the responsibility of preparing plans. Now they prepare plans for this particular region, and all these plans are forwarded to which body? This Committee on District Planning. And that particular district planning committee that is there, it receives all such plans of the various municipalities and panchayats that are there, and it consolidates them into one plan. So it comes out with consolidated plan for the district level, and that particular plan is forwarded to the next authority, that is, as I said, State Planning Board. When State Planning Board is taking up planning, what is the basis of their plan? They prepare those plans on the basis of this particular body, the plans that are forwarded by the District Planning Committee. Clear? Understood this idea? What is the responsibility of this body? Now come to some factual information. Clause 2. The state legislature may by law provide for the composition of the district planning committees, comma, manner in which the seats are to be filled, in brackets here, right, provided not less than 4/5 of the total members, of such committees shall be elected by and from amongst the members of panchayat at the district level and of the municipalities in the district. Clear? So 4/5 members. See, these two provisions say what? What is the number of seats that are there in the committee, this district planning committee? It is decided by the state legislature. How these seats are to be filled, it is also decided by the state legislature. But there is a condition that is imposed, that at least 4/5 of the members of this particular committee will be elected from and amongst. That means all the elected members that are there of the panchayats that exist at the district level and the municipalities that are there at the district level, it is they who elect at least 4/5 of the members of such a committee, and from amongst themselves. They elect them from amongst themselves. 1/5 of the members, remaining 1/5 of the members, who they are, it is completely up to the state government. So they may be elected, nominated, appointed, whatever. Clear? But 4/5 are elected from amongst the members of panchayats and municipalities. And this also 4/5, how many of this 4/5 will belong to panchayat and municipality? It also depends upon the proportion of the population, which means if the population is majorly urban in nature and there are municipalities more, so more members are to be elected from the municipalities. And if there are panchayats, zilla panchayats that are there, that are more, which means the predominantly rural population, so more members are to be elected from panchayats. Clear? Next. After this, just give a comma and write. The functions of the committee, and the manner in which the chairpersons are to be chosen. Clear? So everything is dependent upon the state legislature. Majorly, if you look at this body, it is completely up to the state legislature. Only there is one condition that is imposed. The condition is 4/5 of the members will be elected from and amongst the members of panchayats and municipalities. Clear? Done? Understood what is the objective and what is the composition of the body. Next, Article 243ZE. 243ZE, Committee for Metropolitan Planning. Committee for Metropolitan Planning. First here in the next paragraph just mention a metropolitan area. A metropolitan area is an area having a population of more than 10 lakh. Is an area having a population of more than 10 lakh. So for this particular purpose, that is for part 9A, if you look at the definition of what is a metropolitan area, the definition under the Constitution is that any area which has a population of more than 10 lakh, that is a metropolitan area. That is a metropolitan area. Clear? Next, 243ZE clause 1. Clause 1. There shall be constituted in every metropolitan area, a metropolitan planning committee. A metropolitan planning committee to prepare a draft development plan. To prepare a draft development plan for the region. For the region. Underline this, draft, to prepare draft development plan. Underline this. The legislature of the state, next clause 2. Clause 2. The legislature of the state may by law provide for composition of the committee, comma, manner in which the seats shall be filled, provided not less than two-third of the members of such committee shall be elected by and from amongst the elected members of municipalities, and chairperson of panchayats in the metropolitan area. See, here either members are elected from municipalities or from chairperson of panchayats, not members of panchayats, chairperson of panchayats, they are elected. Clear? Comma, the representation in such committees in such committees of the Government of India, and the Government of state, government of any state or any organizations deemed necessary, functions to such committees, and manner in which chairperson of such committees shall be chosen. Chairperson of such committees shall be chosen. Clear? This is all about the Metropolitan Planning Committee. Clear? With this, we complete the constitutional discussion on municipalities as well as panchayats, that is part 9 and part 9A of the constitution. So the 73rd and 74th constitutional amendment have added part 9 and part 9A to the constitution, also have added the 11th and the 12th schedule to the constitution. And that is the reason why, if you see currently, if you look at the original constitution and if you look at the current constitution, the original constitution had I think 8 or 9 schedules, 8 schedules, and now we have 12 schedules. So schedule 9, schedule 10, obviously anti-defection law, we have already seen that. Similarly, schedule 11 and schedule 12 have been added to the constitution by various constitutional amendments. Clear? Coming to the last part of our discussion here, that is problems of local bodies. Just give a subheading, right? Problems of local bodies. See, actually this part of a discussion that is there, it is not restricted to this particular topic. That is, your paper 2. In your paper 3, there is a topic called as problems of urbanization, etc. That is included here. In fact, in your economics also, you will find that there are certain things called as municipal bonds, etc. And these things are basically used to finance local bodies. So when you are writing these problems, there are 2 or 3 things that you have to take into consideration. First of all, what is the question about? Is the question about problems, whether it has been asked politically or whether the problems are being asked administratively? If the problems are with respect to administrative, like in Delhi, we are currently facing a problem of what? Waste disposal. It is a problem of urbanization. No, you know that in Delhi there is a particular area, all the waste that is elected, solid waste that is collected from various part of Delhi is dumped in that particular region. We have not been able to dispose of, we have not been able to come out with a what you can say a mechanism to dispose of this particular solid waste. That is something, that part of discussion is completely geographic in nature. So in paper 3 of your general studies, you will find there is such things, such topics that have been mentioned. Clear? What I am talking about is more like constitutional and legal discussion that is there. And we can concentrate our discussion to this particular idea. What is the problem? The problem of 3 F's. That is functions, finances, and functionaries. Functions, finances, and functionaries. When it comes to functions and finances of these bodies, they are for this very much dependent upon the state legislature. The constitution conceives the local bodies to be bodies which can act as bodies of self government. They are bodies of self government. How do we describe these bodies? We say it is a form of grassroots democracy. These bodies are there what? For grassroots democracy. That means this self means independent. Independent of any other influence of any other body. Self also means that it will be the people themselves. It will be the people themselves who will be taking up administration of such particular region. The problem is that the constitution, if you look at constitutional problem, the constitutional problem is very much that this power has been given to the state legislature. It is the state legislature which by law actually defines what is the powers and what are the functions that such bodies are going to enjoy. And it is completely up to the discretion of the state legislature. That means it is not the part of mandatory provision, it is a part of voluntary provision. And we find that in most of the states, these bodies are ineffective. Why? Because they have not been properly devolved with these functions. They have not been given these functions. Some functions are given to them which are so insignificant that it does not affect, or in any way empower these bodies. So they are very much dependent upon the state legislature. That is also the case when it comes to finances. So they are very much dependent upon the state legislature or the state government for finances. And we find that when it comes to the state finance commissions, the recommendations of the state finance commission are either not accepted by the state government, which means that they are primarily, even state finance commissions which elaborately recommends what are the steps that should be taken by the state government to empower, financially empower such bodies, we find that it is in most of the states, these recommendations are not accepted. In most of the states, these recommendations are not accepted. Which means what? These bodies are primarily very much dependent upon the state legislature. Clear? Third is functionaries. Now, here is an administrative idea that you need to understand. Local bodies, constitutionally speaking, came into existence in 1993. Yes, they were in existence before that also, but they were not very empowered. The constitutional guarantee was provided to them in 1993. Now, if you look at how these bodies work, that is panchayats and municipalities, these bodies generally, specifically the panchayats, these bodies are working, or they are basically executing functions. For execution and for implementation, they are very much dependent upon the bureaucracy, the state bureaucracy that is there. So you will find at the lowest level, that is at the village level, there will be an individual like a panchayat officer, called by different names in different states. He is like a panchayat officer, and he is responsible for doing what? He is responsible for implementing all the decisions that are taken by this particular body. Like in the block level, there is a body called as block development officer, and the block development officer is responsible for it. At the district level, there is a body called as the District Rural Development Agency, DRDA. This District Rural Development Agency came into being in the 1970s. After when, in 1972, somewhere around 1972, when Indira Gandhi was, when Indira Gandhi was seeking re-election to the parliament, to the Lok Sabha, so she gave a particular slogan which was used, which was very much used during that particular period, that was Garibi Hatao. And with that slogan, when she was actually elected to the legislature and she became the Prime Minister, she created a body called as the District Rural Development Agency, DRDA. And this District Rural Development Agency, it was responsible for complete responsibility of development at the rural areas. All the rural areas that are there, development, the responsibility lied with this particular body. This body was headed by the district collector, is headed by the district collector, still exists, it is still headed by the district collector. What is the problem? With the changes of the 73rd and 74th constitutional amendment, constitutionally we have devolved this power to the local bodies. But administratively this power still exists with the district collector. And the district collector is an office on which the local bodies are primarily dependent upon. That it will be the district collector who will implement all the functions and decisions that are taken by the by such local bodies. So what we see is that the manner in which these bodies functions, that is Panchayati Raj institutions and municipal bodies, they are very much dependent upon the bureaucratic machinery. That means either the state's bureaucratic machinery or the office of district collector, also working under the state itself. So they are very much dependent upon the state administration, rather than being independent and empowered to act independently. They are dependent upon the state administration. And the bureaucracy has worked in such a manner that this dependence has increased, which is against the constitutional, which goes against what democratic idea dictates. Democracy dictates that it will always be the elected representative who will be more, what you can say, in terms of democratic norms, they should be more powerful than any appointed body. These are elected bodies, but they are dependent upon the offices of, such as the office of the district collector. Why is this the case? Because such bodies do not have the right to hire or the right to fire an individual. They do not have personal powers. They have to they have to be dependent upon the state in this case as well. So office of district, वो अपने सामने कुछ समझते ही नहीं है किसी को, district collector है वो, तो वो जिला पंचायत and such bodies, they do not consider these bodies to be very important, because they feel that because the administrative power lies with them, so it will be the decision of the district collector that will be carried out rather than the decisions of such bodies, which is against democratic norms. But this is how it goes. So whether it comes to functions, whether it comes to finances, or whether it comes to functionaries, these bodies are very much dependent upon the state government. And that is the reason why we can conclude by saying we have created a third tier, that is a third level of government, but we have been unsuccessful in creating local self-government. We have created local government, no doubt about it, but we have not been yet successful in creating local self-government because they are dependent upon the state legislature. Clear? Understood this idea? With this, we complete our discussion on municipalities. Clear? And next, we move to, let's take up a small topic, special status of Delhi. Just give this particular subheading. Let's start with this. Special status of Delhi. Special status of Delhi. That is Article 239 AA. Under Article 239 AA, This provision has been introduced in the Constitution by the 69th Constitutional Amendment Act. Before this, that is going back pre-1991, when it was introduced in 1991. Before 1991, Delhi was administered, this particular area was administered by a body called as the Executive Council. Now, there was an Executive Council that was there, and this particular area was administered by the Executive Council. However, the 69th Constitutional Amendment Act renamed this area to be something called as National Capital Territory, NCT, National Capital Territory, and we provided, that is under the 69th Constitutional Amendment Act, the Constitution provided for a state legislature here, or the legislature of NCT, and a council of ministers. Thereby what we did was we provided some autonomy to the region, despite the fact that this particular region is still considered to be a part of union's territory, not a state. It is considered to be a part of union territory, which means that it is constitutionally speaking, it does not enjoy a constitutional status with that of the union, a constitutional relationship with that of the union. It is dependent upon the union. But because of various reasons, like the Executive Council not being a very effective body, and second of all, the increasing population in the region, without the region, if representation was not given to this region, it would have been considered to be undemocratic. Looking at all these factors, we amended the Constitution and provided in 1991 the NCT region, National Capital Territory, with a legislature. The members of legislature in this particular region are all directly elected. None of them are nominated members, they are all directly elected. You know this because right now there are a lot of news about elections, because on the 8th of February, elections to the Delhi legislature is due. So the 70 members that are there in this particular legislature, they are all elected members. There were no members who were nominated. Here, there was a position created called as the Lieutenant Governor. Previously, an administrator which is appointed to the all UTs, an administrator of Delhi, that particular office, the name of this particular office was changed, and it was now the Lieutenant Governor of Delhi. So we provided for a Lieutenant Governor, we provided for a legislature, and we provided for 70 members of this legislature, and we created another body, that is the body of the Council of Ministers. The body of the Council of Ministers. We extended the provisions of Part 15 of the Constitution, that is with respect to the elections. We extended that particular part, that is Article 324, 325, 326, 327, not 328 but all 329 also. So 324, 325, 326, 327 and Article 329. These were extended to to Delhi region as well. What is Article 328? It deals with the power of the state legislature to make laws with respect to elections. That power is not being given to the legislature of Delhi. It is completely up to the Union Parliament to make laws on how elections are to be conducted in this particular region. Now, the Constitution also says that the Chief Minister of Delhi is to be, he is to be appointed by the President of India, not by the Lieutenant Governor. He is appointed by the President of India, not by the Lieutenant Governor, which is generally the case with other states. Now, which is generally the case with other states. Who appoints the President, the Chief Minister of other states? It is the Governor. In this case, it is not the Lieutenant Governor, it is the President who appoints them. And other Council of Ministers are appointed by the President on the recommendation of the Chief Minister. On the recommendation of the Chief Minister. the Council of Ministers of Delhi, the maximum strength of the Council of Ministers of Delhi is 10% of the Legislative Assembly, which means 7, which means one Chief Minister plus other 6 Council of Ministers. Clear? Unlike the other state legislature wherein it says a maximum limit of 15% of the Legislative Assembly or 12, whichever is higher. This is what is mentioned in the state legislature. Either it is 12, minimum 12 Council of Ministers are there, or maximum 15% of the state legislative assembly, whichever is higher. In this case, it is 10% and not 15%. It is 10% and not 15%. Clear? The Constitution further says, that the legislature or NCT of Delhi will have all the legislative powers that are mentioned in the 7th schedule of the Constitution, which is mentioned in list 2 and list 3, which means state list and concurrent list. All the legislative powers are also given to the legislature of Delhi, barring subjects of public order, police and land. These 3 subjects that are there, it is kept outside the jurisdiction of the legislature of Delhi, which means in these 3 cases for Delhi, the legislative power belongs to the parliament and not to the legislature of NCT. Public order, land and police. These are the 3 aspects. The Constitution under Article 239A also says, it also mentions that the Lieutenant Governor of Delhi will act in accordance to the aid and advice of the Council of Ministers headed by the Chief Minister, provided the Constitution, under this Constitution he is to act in his discretion, which means yes, there will be a Council of Minister and a Chief Minister, and it will be the Chief Minister and the Council of Minister who will aid and advise the Lieutenant Governor, except for those cases wherein the Lieutenant Governor is to act in his discretion. The Constitution also mentions, provided if there is a difference of opinion, among the Council of Ministers, that means within the Council of Ministers and compared to the Lieutenant Governor, in that case such a matter will be referred to the President and will be acted upon. That means how it is to be done, how it is to be taken up, it is decided by the President. No one can challenge the decision of the President. The Constitution also further says, if the act or if the Lieutenant Governor feels that in any case there is an emergent condition which requires immediate action, in that case it is the decision of the Lieutenant Governor which prevails over the decision of the Council of Ministers. यही जड़ है problem का, ठीक है? This is the basic idea. It says, what? If there is a difference of opinion, then such a matter will be referred to the President and will acted upon as decided by the President. It also says, if there is an urgent, if the Lieutenant Governor feels that the matter is of urgent importance, in that case, he will act in accordance to what he deems necessary. That means, in that case, it is the discretion of the Lieutenant Governor and he will act in accordance to what he considers it is necessary to be done, even if it is contrary to the advice of the Council of Ministers. Clear? And this is the reason why in Delhi, in this particular region, you will find that the Council of Ministers and the headed by the Chief Minister, this body is not as powerful as the Council of Ministers of the state. Clear? Why? First, the legislature has been deprived of 3 powers, that is public order, police and land. This does not fall under the purview of the legislature. When we say it does not fall under the purview of legislature, it means that while executing any such laws, the state government or the state council of minister, the NCT's council of minister has no role to play. So that restricts the power. And second of all, the restriction also comes because of the office of the Lieutenant Governor, because he is appointed. Lieutenant Governor is appointed by the President, and if there is a difference in opinion, then the Lieutenant Governor can refer to the matter to the President, and accordingly he will be, it will work in accordance to whatever is decided by the President. However, the Constitution also says, if it feels, if the Lieutenant Governor feels that there is a matter of public importance, of urgent requirement, in that case he will act in accordance to whatever he wants to act, or whatever he deems necessary, even if it is contrary to the advice of the Council of Ministers. Clear? So this is the constitutional position. इसकी वजह से there were lot of problems between the Lieutenant Governor and the Council of Ministers. Now the problem is that if you see till now, that means if you see since 1991, after the constitutional amendment and coming up of this legislature, generally it was the case that the government in the center and the government in the NCT, they were the same. The same political party was in power in the center and the NCT. That was also true for, if you look at the last 10 years, that is before the coming up of Aam Aadmi Party, before the coming up of Aam Aadmi Party, if you look at the last 10 years, that last 10 years was, obviously Sheila Dikshit was the Chief Minister here. She actually was the Chief Minister for 15 years, not 10 years, 15 years. But this 10 year was under the UPA government. Before that, if you go back before that, the constitutional position of these two, they were just evolving. And because the center government, at the union government, the Prime Minister was Atal Bihari Vajpayee. So Atal Bihari Vajpayee was a different kind of personality altogether. So that was the reason why during his tenure as the Prime Minister of India, despite the difference of political parties, different political parties coming to power at the state, he did not exert, union did not exert upon the states, or for that matter the NCT. So till now things were going on very well. But in 2015, when the Aam Aadmi Party came to power, there were two reasons that led to this conflict. First of all, the BJP felt that it was it was the BJP who deserved to be in power here, because there were two elections that were held. In the first elections, BJP got 32 seats, which meant that they were only shy of 3 seats to come to power here. They required only 3 to 4 seats to come to power, which they did not get. Why? Because 27 seats were of the Aam Aadmi Party and 9 remaining seats that were there, it was of the Congress. So neither Aam Aadmi Party, they could go, they can come up with a coalition with Aam Aadmi Party. Obviously Congress की तो कोई बात ही नहीं है, फिर they cannot come into a coalition with the Congress Party also. And the Congress Party supported the Aam Aadmi Party and they remained in power for 49 days. After that, Arvind Kejriwal resigned, saying that because of the Congress coalition there were a lot of problems there, and hence there was for a certain period precedence rule that was imposed in the state. During this particular period, the BJP was, they thought that as soon as elections are to be conducted, because of the political, what happened between, the political developments that were there, it was very likely that the BJP came to power. But that did not happen. The result was exceptionally in favor of the Aam Aadmi Party, wherein they won 67 out of the total 70 seats. And because of this particular political development, there was lot of problems between the Lieutenant Governor and the office of the Council of Ministers. To an extent wherein it was appealed in the Supreme Court also to define what is the power of the Lieutenant Governor and what is the constitutional power of the Chief Minister. The Supreme Court did nothing. Basically, the Supreme Court heard the matter. The Supreme Court said what? The decision of the Supreme Court said that the the decisions of the Council of Ministers, because they are democratically elected, should be respected by the Lieutenant Governor. That's it. The Supreme Court gave this decision, which means the Supreme Court did not exert which authority had power. That is, should the Council of Ministers or did the decision of the Council of Ministers override the Lieutenant Governor, or will the decision of the Lieutenant Governor override the Council of Ministers? This was not elaborated upon by the Supreme Court, because the Constitution is very clear about it. It is the will of the Lieutenant Governor that will prevail. And that is the reason why there has been number of conflicts in the last 5 years of the Aam Aadmi Party government that is there. They have always been under a conflict with the central government. They have always been under the conflict of the central government. Initially, for the first 2 years, even those people who have voted for Aam Aadmi Party, they were very frustrated. They said that, what is the Chief Minister doing? For everything they are blaming the union government. And the Aam Aadmi Party initially understood that this is politically not right to do something like this. So what he did was, for the next 3 years, he stopped doing that. But in 2015 general elections, 2019 general elections, he again started the same idea. Okay, Delhi will get statehood, etc., etc. And since almost 8 months have elapsed after that, and the elections are due. So after the elections, which is again very likely that, as the exit poll says, that it is very likely that the Aam Aadmi Party wins again. So if the Aam Aadmi Party wins again, this conflict at least continues for the next 5 years. ठीक है, तो वो entertainment चलता रहेगा. That is the case here. ठीक है. When we meet tomorrow, I'll just dictate what are the ideas here, and then we'll move forward.